Doctrine of Waiver. Can a citizen waive his fundamental right? The doctrine of waiver has no application to the provision of law enshrined in Part 3 of the Constitution. It is not open to an accused person to waive or give up his constitutional rights and get convicted. The question of waiver directly arose in Bashir Nath versus Income Tax Commissioner, AIR 1984. The petitioner, whose case was referred to the Income Tax Investigation Commissioner under Section 5(1) of the Act, was found to have concealed large amount of income. He, thereupon, agreed at a settlement in 1954 to pay Rs 3 lakhs in monthly installments by way of arrears of tax and penalty. In 1955, the Supreme Court in Muthaiya versus IT Commissioner, AIR 1956, held that Section 5(1) of the Taxation of Income Investigation Commission Act was ultra vires of Article 14. The petitioner then challenged the settlement between him and the Income Tax Investigation Commission. The respondent contended that even if Section 5(1) was invalid, the petitioner, by entering into an agreement to pay the tax, had waived his fundamental right guaranteed under Article 14. The majority expressed the view that the doctrine of waiver, as formulated by some American judges interpreting the American Constitution, cannot be applied in interpreting the Indian Constitution. The court held that it is not open to a citizen to waive any of the fundamental rights conferred by Part 3 of the Constitution. These rights have been put in the Constitution not merely for the benefit of the individual but as a matter of public policy for the benefit of the general public. It is an obligation imposed upon the state by the Constitution. No person can relieve the state of this obligation, because large majorities of our people are economically poor, educationally backward, and politically not yet conscious of their rights. In such circumstances, it is the duty of this court to protect their rights against themselves.